The judge in President Trump's hush money trial told the jury that they don't even have to agree on the crime. They can all think, I think his hair is a crime. 4 of them, I think his suntan is a crime. And 4 of them can say, I think, he falsified checks, whatever. Whatever they think the crime is, because it wasn't really defined, even if they don't agree on the crime, if 12 of them thinks he committed some crime, well, then he's guilty. I've never heard that before. I've served on a jury. I've served on a jury with multiple counts. We had to discuss each count, and we found this person guilty on some counts and not on others. It would have been the easiest thing ever. We could have been done in 10 minutes if all we had to do was just, hey, these 7 counts on this guy, does everybody agree he did one of them? Yeah. Okay, we're out of here. Is this normal? Andrew Bailey is here. He's the Missouri Attorney General, kind of knows the law. Attorney General Bailey, welcome to the program.
Thanks for having me on.
So, again, I don't know the law, but this does not seem like the American way of justice in our courts. Am I wrong?
No, you are absolutely right. This reeks of desperation by the prosecutor and the judge to obtain a conviction. If people were not previously convinced that this was an illicit witch hunt prosecution, they should be so now. This is insane. Look, since 2020, the United States Supreme Court has said that jury unanimity in criminal law is required under the Sixth Amendment to the United States Constitution. It was not always that way. There were 2 states prior to 2020 that did not require jury unanimity under the Sixth Amendment in criminal trials, Louisiana and Oregon for lesser offenses. And the Supreme Court fixed that in 2020. And so for this prosecutor and this judge to say, hey, whatever you think, go ahead and do what you want, it violates the Sixth Amendment. It violates the president's due process rights, because how's he supposed to know how to offer a defense if he doesn't even know what the target crime is that is an element of the offense for which he's charged? But then also, it empowers this jury to become a roving commission. And again, that reeks of desperation. They don't care. They're going to throw everything against the wall, listen to all this evidence, not give the jury written jury instructions, and just convict them of something, whatever you want.
Well, there's, 32 charges, 32 counts, 34 counts. So if 2 of them believe, well, he's guilty on number, 29, and 2 of them believe something else, but they don't agree on the same counts, how is that justice?
No, I think that's absolutely right. And again, it creates a roving commission, and that violates the basic constitutional tenets that underpin the due process clause and the Sixth Amendment right to a jury trial that has been incorporated against the states, and certainly at least since 2020. And again, I think it's desperate. I think it's throw everything against the wall. It also reminds me of, there was a Roman emperor who used to nail the laws to the highest point on the columns so that the Roman citizens wouldn't be able to read them. And that's a lot what this is like. I mean, the judge is saying, jury, I'm going to charge you to find a crime, any crime you want, and I'm not going to let you read the jury instructions. Trust me, you guys just go back and pick something you want to convict them of.
Okay, so tell me what the jury instructions mean, and why would he not print? Because I understand also that it is clearly printed all the time. So
that's right. I've never tried a case where you didn't give the jury instructions. And why would you not want to? Again, that's the law. Judges determine law, juries determine facts, and it's up to the jury to apply the facts to the law. And so in closing argument, the prosecutor gets up and says, here's the elements of the offense, here's the evidence that proves each of these elements, and it's like a checklist, and you tick down it, and then you show them the verdict form and say, this is how you find them guilty. And if you're the defense, you stand up and say, the state didn't prove this, they don't have proof beyond a reasonable doubt of that. And it etches in the jury's mind what to look for in that instruction packet when they go back and deliberate. But how is the jury supposed to apply facts to the law if they can't see the law in front of them?
Also, may I ask, when the shoot. He did something. Oh, in the closing arguments for the prosecution, didn't they introduce new evidence or evidence that wasn't presented and he let it ride?
Completely objectionable. Should have been stricken from the record, and the jury should have been admonished to ignore that. It's called fact, not in evidence. It's one of the first objections you learn in any evidence class in law school. And to have the prosecutor for the state of New York, Matthew Colangelo, Alvin Bragg, having that team stand up and testify as if they're witnesses to facts that had not been introduced is completely impermissible. It demonstrates an abuse of the judge's discretion. It should have been stricken from the record. The jury should have been admonished. But again, I'm going to go back to this idea of a roving commission. Think about our experience under colonial England, where general warrants were issued by magistrates and the British soldiers could search your home and quarter in your home for no basis whatsoever, just on any level of suspicion. And you didn't even have to be charged with an actual offense that you would then be able to defend against. Vague allegations were sufficient to jail you. And so the founders erected these constitutional barriers to that kind of government intrusion into our individual liberties. And again, the Sixth Amendment requires jury unanimity, which has been violated here, but it also prevents the due process clause also prevents a roving commission where the law is so abstract that the jury can roam freely through the evidence and choose any facts it wants to create liability. That is not that is not what this country is founded upon. That violates the president's constitutional rights. And it once again just demonstrates this was never about a legally valid conviction. This was never about an actual crime. There is no crime. This was always about taking President Trump off the campaign trail, and that ends up violating all of our rights.
Okay, so Andrew, I'm thinking about why this guy would do this, because I would imagine this is a slam dunk overturn. Wouldn't it be?
Yeah, absolutely. Absolutely. It should have been dismissed at the close of state's evidence for failure to actually prosecute a criminal offense, failure to offer proof beyond a reasonable doubt on some of the elements. It then should have been dismissed once again at the close of all the evidence. This should have never even gone to the jury. And the fact that they've now rigged the jury process to avoid the unanimity requirement and to create this roving commission just once again is one more piece of evidence to prove the illicit nature of the witch hunt prosecution.
So do you believe this was done possibly excuse me. Do you believe this was done possibly because they just want the felon name after and then just dispute, well, it was some, conservative court that overturned it. We know the truth. I mean, that's the only reason I can think of why you would do this. Why would a judge want to be overturned, especially when it is so clearly going to be overturned?
Glenn, I think you're absolutely right. I think two other points to make here. Again, the process and the timing. I mean, this is a crucial period when President Trump needs to be courting the electorate and public, and instead he's tied down in a Manhattan courtroom. But secondly, think about how long an appeal takes. That doesn't happen overnight. I mean, to the extent he is convicted, to the extent they obtain an illegal, illicit conviction this week or next, sentencing will be pushed out 45 to 60 days at most, and then an appeal is going to take a year or more. And so this takes us in, even if President Trump is elected president, this will haunt him and this will undermine the first few years of his administration. They've poisoned a well that we'll be drinking from for years from now.
I mean, you want to talk about the end of the republic. It's this kind of stuff that ends the republic. And because it's not just about him. This goes back to what Stalin created, what the King George created. Find me the man, I'll find you the crime. There is no justice if things like this happen. One last question. I served on a jury once, and it was a serious case, but not a murder or anything else. But it was abuse of a wife, and we had I don't know how many charges, and we kept calling the judge in because we thought the judge was our friend and fair, And we'd ask him, and he'd say, I can't tell you that. I can't tell you that. Here are the instructions. You have to go. And we'd call him back in. I can't tell you that. Here are the instructions. And we couldn't agree on all of the counts. And so we ended up on maybe 2 counts out of 8 or something like that because we were split. If we would have been able to say, oh, you 4 want this, and you 4 think that case, and that 4 think this, we would have been out of there by now. Does it say anything that they have such a wide berth to agree on anything, and it takes them a while to get through this? I mean, I would have been done. We would honestly, if we had those instructions, we would have been done the first day.
Yeah, I mean, that's right. And again, that's why jury unanimity is so important to our constitutional structure and to our individual rights, and also the due process clause to prevent that kind of roving commission. I mean, the prosecution's case here is best summed up as there is no crime, so let's see how much garbage we can throw on a wall, see if any of it sticks, and try to convince someone that it's criminal behavior. And the judge is going to collude with us, not allow the jury to see the law, and then agree that, yeah, you are a roving commission. Anything you want to find that's criminal, it's a grab bag. You pick it, you choose it. You don't have to agree. Let's get out of here with a conviction as fast as we can. It undermines the credibility of our criminal justice system. I also think it's dripping with irony that this is happening in a state like New York where they're not prosecuting actual criminals.
I know.
I mean, this is a state that prides itself on criminal justice reform and, bail for everyone with cashless bail for everyone and one standard of justice, as Alvin Bragg's mantra on his website. I mean, how can he even look at himself in the mirror and keep a straight face with that kind of nonsense going on?
I'm sorry. No, I promised one last question. But again, one last question. The jury just sent the judge a note. They want to reread the instructions, beginning with how they should consider facts and what inferences can be drawn. What do you take from that?
I think that's problematic. It means that they know that they don't have direct evidence to prove some of the elements of the offense. But remember, there are two attorneys on that jury. And those attorneys are telling them, look, we don't need direct evidence. Circumstantial evidence, which includes reasonable inferences, is sufficient to obtain a conviction. So it means they're stretching. And I think it's a reasonable inference for us as outsiders to draw that those attorneys are inviting that jury to stretch and use circumstantial evidence to try to find any crime.
Jeez. Thank you so much, Andrew. I appreciate it. Andrew Bailey. He's the Missouri Attorney General. I really appreciate it. Thank you.
Appreciate you having me on. Thank you.
God bless.